Live in 5 seconds. Okay, we are live and I posted the link. Good evening. If you're listening to this roundtable with Dr. Katherine Southwick in Virginia and soon to be Dr. Michael Becker in Dublin. I'm Zani and I'm hosting this FORSEA Dialogue on democratic struggles across Asia. And we have a very, very timely and important and very relevant subject of the Gambia versus Myanmar public hearings coming up in the next 10 days at the International Court of Justice. For those of you who are not lawyers, the ICJ or International Court of Justice is not a criminal proceeding. It is a state dispute, legal dispute between the state of Gambia in Africa and Myanmar, my own birthplace or country, over whether Myanmar has violated, as a state party or signatory to the Genocide Convention, the convention's obligations, and it's an interstate treaty. And so this is not about trying Aung San Suu Kyi or the Burmese generals or any individuals. This is one of the crucial points that we need to understand. This court does not establish or assign individual criminal responsibility to any human leaders, civic, military or religious who may have been involved in the persecution of Rohingya. So to discuss that, because I am not a legally trained person, I've invited two of the best known legal scholars I know in this area of international law. Michael Becker is an adjunct assistant professor at the Trinity College in Dublin. He's also a former associate legal officer with the ICJ for 5 years, from 2010 and 2014, and he's finishing his PhD in the Truth and Reconciliation bodies at the University of Cambridge in international law. And then in Virginia, we have Dr. Katherine Southwick, who had worked in so many different international legal contexts, including the International Criminal Tribunal for Former Yugoslavia, US State Department, and also worked in non-governmental sectors for the American Bar Association in Africa and Asia on different rule of law and constitutional projects. And she is currently a contractor specializing in atrocity crimes prevention with the US Holocaust Memorial Museum. Welcome to both of you, and thank you so much for taking the time to share your thoughts. Now, Mike, can I ask you to, to offer your thoughts on the upcoming public hearings first?
Sure, I'm happy to do that, and thanks for having me on again, Zarni, and good to be here with Katherine again. Yeah, I think it makes sense to start just by explaining what this procedure, what this hearing happening in a couple weeks' time is about, in order to clarify kind of where the case stands for people who've been following these developments. And then maybe we can get into some of the other issues that have surrounded this lately, including the question about who is lawfully entitled to represent Myanmar in this case. So assuming that the hearing goes ahead, because there are some reasons now to think that it might not, because this question has been raised about who can legitimately stand in and represent Myanmar. But assuming it goes ahead, the issues here are about jurisdiction and admissibility. So it's really important for listeners to understand this is not the hearing where the evidence and the arguments against Myanmar are going to be considered by the court. That's what we refer to as the merits of the case. That's the claim that Myanmar has violated the Convention on the Prevention and Punishment of the Crime of Genocide, that it's breached its obligations under the Genocide Convention. That's what the main case is about, that the Gambia has brought, but that is not what's going to be heard here. This is because when a state is sued, when you're the respondent state or you're the state defending yourself, you have the right to challenge the court's jurisdiction, which means the court's power to hear the case in the first place, or to raise concerns about admissibility, which is similar to jurisdiction, but essentially means, are there reasons why it would be inappropriate or incorrect for the court to move ahead with the case? All right, so Myanmar has before the coup last year, the Myanmar government had, as it was absolutely its right to do, filed these preliminary objections to jurisdiction. That is what the court will be now hearing in the oral proceedings this month. Now, we don't know exactly what objections Myanmar has raised because the documentation they will have filed with this doesn't become public until the hearing happens. But it's not too hard to guess because they made the same types of arguments when they tried to prevent or argued against the court indicating provisional measures back in January 2020. And so when that hearing on the emergency request for kind of emergency measures that the Gambia made, right when the case was first filed, back in December 2019, when Myanmar and Aung San Suu Kyi very memorably appeared in Great Hall of Justice, Myanmar made these same types of objections to jurisdiction, and now they get another chance to do it. So that kind of tells us what they're likely to argue. So I'll just try to run through very quickly what my best guess would be about what they will argue. The first idea is that they will say, well, this case can't go forward, the court shouldn't hear it because the Gambia is just acting as a proxy for the Organization of Islamic Cooperation. And we know it's true, and nobody kind of rejects the idea that the Gambia brought this case with the support and the backing of the OIC, an international organization made up of Muslim majority states. And that argument was made back at the provisional measures phase. The court rejected it, made the point that the Gambia is a sovereign state. It's exercised its own sovereignty by bringing this case. And whether the Gambia has done so with moral support or financial support from other states or an international organization isn't relevant. That doesn't preclude there being a dispute specifically between the Gambia and Myanmar, which is a requirement for the case to go forward. So I'm quite confident if they make that argument again, it will fail. Similarly, there's this idea you have to have this bilateral dispute between the two states. And Myanmar tried to suggest before that the Gambia hadn't taken the necessary steps to show that there is a disagreement between specifically the Gambia and Myanmar prior to the Gambia having filed the case back in 2019. And the Gambia has pointed out that it sent, among other things, a diplomatic note to Myanmar, specifically alleging that it was in breach of its obligations under the Genocide Convention. Myanmar never responded to that, and the court found that at the provisional measures phase perfectly satisfactory in terms of demonstrating that a dispute exists. So they'll probably make that argument again and again. I imagine it would be rejected unless there's some really outstanding piece of evidence that we have never seen before. I just can't imagine that. Okay, more technical here, and I'll try to be very brief. Myanmar has taken a reservation to a provision of the Genocide Convention, Article 8. And they will make the argument, I assume, that because they took that reservation, the court has no jurisdiction. Now, this case has been brought by the Gambia under a different provision of the Genocide Convention, Article 9. That provision of the Genocide Convention is where states agree when they sign up to the treaty to allow disputes relating to the treaty, so disputes about whether a state is committing genocide, for example, can be decided by the ICJ. And crucially, when Myanmar joined the Genocide Convention many decades ago, they did not take a reservation to Article 9. They consented at that time to allowing the ICJ to hear disputes about their performance under the treaty. Article 8 is something else. It says that parties to the Genocide Convention can call upon UN organs to take action as appropriate to prevent and suppress acts of genocide. It's kind of a strange provision in the treaty in the first place because states could do that anyway, really. It doesn't really create any new rights for states. And the fact that Myanmar opted out of that provision when they joined the Genocide Convention is curious. I don't think it's entirely clear what the import of that reservation is. But the argument that Myanmar has made before, which I assume they'll make again, is that because the Gambia hasn't been directly injured by the acts that Myanmar is accused of, they are what we call a non-injured state, that it's only Article 8 of the treaty that would give them the right to kind of call the UN machinery into action, not Article 9. And so the basic argument here is that Myanmar will say, yes, we consented to states that have been injured to bring cases against us, but we never consented to allow non-injured states to bring cases against us. That's a little bit technical. They've made this argument already, and it's already been rejected by the court, which made the point that Article 8 and Article 9 deal with different things, and only Article 9 is about bringing cases to the ICJ, and Myanmar has accepted that provision. So I again can't see any chance of that argument succeeding. And finally, a related argument is just a more basic point that I assume Myanmar will make, is to say that, well, non-injured states in general have no standing, they have no legal right to bring cases here. You have to be an injured state. So this is a similar argument. And until recently, that type of argument might have had some sway, but over the past 10 years or so, we've seen a few cases at the ICJ where non-injured states have brought cases trying to enforce what we call obligations erga omnes. So obligations under international law that are owed to everyone. And as a consequence of which, any state to which that obligation is owed has a right to invoke the responsibility of a state to say, you are violating that rule of law, and if possible, you can bring them to court, bring them to the ICJ. We saw that in the Belgium-Senegal case 10 years ago, where Belgium brought a case under the Convention Against Torture against Senegal. And the court found that, well, even if Belgium could be construed as an injured state in some ways because Senegal had refused to extradite Hissène Habré to Belgium, that actually didn't matter. They had the right, they had standing to bring the case anyway because of the nature of the obligations under a human rights treaty like the Torture Convention. And that same argument applies to something like the Genocide Convention. So it seems pretty clear now that the ICJ has accepted the idea that a non-injured state like the Gambia has the right, has standing to not only invoke the responsibility of another state that's a party to the Genocide Convention like Myanmar, but in fact to bring a case at the ICJ to try to enforce those obligations. Now, at the provisional measures phase, the court similarly rejected this type of argument from Myanmar. I can't imagine they'll do anything differently here. We saw Judge Shui, the judge from China, is the only judge who in a separate opinion expressed doubts about the idea that non-injured states can bring such a case, but I can't see that view gaining momentum here. I think that ship has sailed at the ICJ. So those are all arguments that were made before. They were all rejected by the court. I think Myanmar will make those same arguments at the hearing this month, and the ICJ will reject them all again. The only argument that might be new, and maybe this is something Katherine would want to speak to at some point based on her expertise, but I can maybe imagine an argument from Myanmar suggesting that the Rohingya, and they probably wouldn't use the term, but the group describing themselves as the Rohingya in the way that Myanmar might approach it, don't qualify as a protected group under the Genocide Convention. Okay, so under Article 2, the Genocide Convention protects what we might call national, ethnical, racial, or religious groups. So it's possible, I can imagine this, Myanmar trying to argue that there is simply no such thing as a Rohingya group, that qualifies for protected status under Article 2. And that would be consistent with the way the the deposed government refused to acknowledge the Rohingya as a group, or indeed even to use the word Rohingya during the ICJ proceedings on provisional measures. So that could also be something that comes up at a later phase of the case, but they could say the court has no jurisdiction because the Rohingya aren't a group that fall within the protections of the Genocide Convention. Again, I have very little doubt that the court would reject that type of argument. I think it's a reason that argument wasn't made earlier is maybe because it's so ludicrous, it's so flimsy that Myanmar didn't even, or Myanmar's legal counsel didn't even want to make that type of argument. But I mention it here only because the judge ad hoc that Myanmar appointed for the case, because Myanmar and the Gambia are each allowed to add a judge to the sitting panel of judges at the ICJ. Myanmar's ad hoc judge, who voted for the provisional measures, so voted against Myanmar, against the country that had appointed him, nonetheless pointed out in something he wrote that question of whether the Rohingya constituted a protected group under the Genocide Convention hadn't really been addressed. And so that anything the court did in terms of ordering provisional measures was without prejudice to any further arguments that Myanmar might want to make about that. So in a way, that was almost an invitation for Myanmar to raise some objection to that here, but I think, again, it would fail. So that's all I wanted to say about that. These are the types of arguments we could expect to see at the hearing this month if it goes ahead. And I think they're all likely to fail, which would then allow the court to move the case forward after another period of time where the parties will make further submissions on the merits, so about the Gambia's actual claims, and we'll move a little bit closer to actually having a hearing where the court hears the final arguments about whether genocide took place or not.
Thanks, Mike. You were listening to Michael Becker from Trinity College, Dublin, talking about quite precisely the type of argument that he thinks that Myanmar legal team will make. Mike, your a short overview coughs up a lot of issues here, both the judicial and non-judicial / strategic issues with respect to the Myanmar military that attempts to take the contested space as the state party in the Gambia versus Myanmar. So let me now turn to Katherine and see what she has thought about the proceedings and in what larger context that they should be understood. Katherine.
Yeah. Thank you, Zarni, for inviting me to this discussion, and thank you, Mike, for also being here and for your always very lucid and thoughtful analyses on these issues. So I'm going to just take a much more broader perspective on how we might think about the ICJ case in the bigger context of seeking justice and some sort of solutions for the Rohingya and the underlying problems and causes of why the Rohingya are in the crisis they've been in the first place. Also to sort of say how the ICJ matters, but also how it and other judicial processes can sometimes have some risks and downsides that we can do things to mitigate if we're aware of them. So the bigger picture here is that the Myanmar military has apparently been committing genocide against the Rohingya for many years. And now, since last year's coup, it is engaged in civil conflict with the rest of the country. When situations like this arise, the international community has, under variable obligations that we can debate, has a responsibility to prevent and punish mass atrocities, protect vulnerable groups, and maintain international peace and security variably under the Genocide Convention, the responsibility to protect commitments, the UN Charter, Universal Declaration of Human Rights, and so on. But there's no formula or prescription for how we meet that responsibility to prevent or protect, as every situation is different. And there are competing different interests in every situation that influence decisions on what people decide to do. But that lack of sort of specificity can lead to sort of inaction or symbolic posturing, or other limited responses like limited sanctions or so on, that can be difficult to define or measure success. So the ICJ case is an effort to kind of live up to this obligation to prevent and punish under the Genocide Convention explicitly. And so that, and some of the other things that are done may be very difficult to, in the real sense, to actually launch and accomplish in this complex political environment like the UN and international affairs. So whenever anything is done, like bringing a case to the ICJ, we can claim it as a kind of success. But if we measure success according to whether atrocities were actually prevented, it's very difficult to prove that negative scenario, that something we did launching a case actually stopped something from happening. And of course, if success is defined as like reducing risk factors for atrocities, or stopping violence, or compensating and restoring rights to victims, then often, most of the time, we are falling short from success. And the ICJ case kind of tracks this contradictory notion of success in international response, at least at this stage, because it is without question a success that the Gambia brought this case at all. Many people for a long time speculated and doubted whether any country would actually stick its neck out to do this. So the fact that a country, no less from the global south, with no obvious connection to the Myanmar Rohingya crisis, is making this claim is a very powerful act in actualizing or sort of performing this norm underlying the convention that the crime of genocide against any protected group is a crime against all humanity. And conveying that these principles also matter greatly to smaller, non-Western powerful countries, less powerful countries. So in the ICJ, as you can hear in how Mike describes the processes, is an august forum that will treat this case with a great deal of care and detail and seriousness, as in the process, it creates at least an authoritative record of facts and considers these grave allegations under international law. There is sort of a measure of justice in just reaching this point, regardless of the outcome, as there is with the other justice-seeking efforts that have been launched in a kind of avalanche of accountability efforts in the last 3 to 4 years, such as the Independent International Fact-Finding Mission for Myanmar, the People's Tribunal of Myanmar, the Independent Investigative Mechanism for Myanmar, the International Criminal Court investigation, which was launched in November 2019, the same time as the ICJ case, the Burmese Rohingya organization's universal jurisdiction case in Argentina, the various travel bans, asset freezes, sanctions from the US, the EU, and other governments, the lawsuit against Facebook, the corporations that are withdrawing operations in the country. Most recently, I read Total and Chevron, which is quite amazing. This is all a testament to coordinated advocacy on the part of Rohingya and other Burmese activist networks and organizations. And the breadth and variety of legal responses signals that atrocity prevention and accountability norms are stronger than they were 20 years ago. At the same time, as many have pointed out, precisely because the ICJ takes these claims seriously, and as do the other judicial processes, they will take a long time and their outcome and impact is uncertain. So it's difficult to say whether the ICJ case ultimately will be a success for Gambia and by extension, the Rohingya. These processes apply pressure on the military regime And the National Unity Government can pledge its willingness to cooperate with them to strengthen its own claims to legitimacy and to help actualize these crucially fundamental norms of equality among all the groups within Myanmar. If alleged perpetrators are ever actually arrested and convicted at the ICC, that will be quite meaningful to some. But these processes, as many have pointed out, do not automatically improve humanitarian responses, amend the Myanmar constitution. They do not eliminate discriminatory laws, not directly, and they do not directly support restorative justice among divided communities or build rule of law in Myanmar. They are complementary to and not a substitute for long-term processes. And that essential work of social and political change is happening in Myanmar through the Nui revolution, the ongoing work that you, Zarni, and other activists, including Rohingya refugees, have done to promote inclusion and pluralism inside the country. I want to also stress, I don't want to take too much more time though, that enforcing international law does not only happen in a court, it happens through our behavior. Now, if we, the international community, are effectively living up to or enforcing obligations to prevent and protect populations from mass atrocities, we should continue to focus on the immediate urgent needs of the affected and vulnerable populations, grounded in their understanding of what justice means and what they want from us. Now, their voices and say over what happens are too often missing from these discussions and decisions. And I'm not necessarily blaming the ICJ. It's not necessarily a flaw in the design of the ICJ, but it's an issue that somehow we have to mitigate against in this whole process and in this whole discourse. So one of my recommendations out there is that we international actors who observe and work on this try to develop, perhaps collectively, a more systematic, deliberative approach to engaging Rohingya perspectives in Bangladesh, Rakhine if possible, and elsewhere, so as to more effectively, as maybe Habermas would say, emancipate the voices of the marginalized, or as Spivak might say, to let the subaltern speak. At some point, I don't want to speak too much longer, but 2 Rohingya youth leaders did speak out in May 2020 after the Myanmar submitted its first report to the ICJ. And if you don't mind, Zarni, I want to read part of what they wrote so that their voice is in this discussion.
Yeah, please.
This was published by Zahidullah Shohid and Abdullah Zubair, who are youth leaders in the refugee camps in Bangladesh in the frontier. This is what they write. Since we arrived in Bangladesh, hundreds of international delegations have come to speak to us at the camps. They have promised us that through these international courts, they will work towards justice for the Rohingya people. Maybe they stopped listening when we explained what justice means to us. For us, justice means going home as soon as possible. It means being given rights and citizenship in Myanmar. It means security and the ability to call ourselves Rohingya. We do not need an international court to tell us what happened to us was a genocide. We know it was genocide. The world knows it was genocide. The world has heard our story and knows our pain. If the ICJ is going to take 5 or 10 years, then we ask the international community, what are you going to do about the abuses and injustices that are happening today? What action will you take to help us go home? How can we expect it to wait 5 or 10 years without education or livelihoods? Perhaps the international community thinks justice is something that happens in a court in Europe. The fact is, Rohingya need justice in Myanmar and Bangladesh. We want to go home, we want to go to school, we want to work, and we want to be safe. That is what justice means to us. Now, last little point on that. These are 2 voices out of 2 million plus, but there are other perspectives, and but it's just imperative. If I were representing them, I would be looking to whether, I would be asking myself, among the legal options or political, among any options out there, how much of how much time and resources should I be putting into ICC or ICJ, long judicial processes? Those things are useful. They can happen. But I wonder, I just put out there and question how much more that the international community, legal community even, should be thinking about how we actually measure success and think about actualizing justice when it is needed now. Thanks.
Thank you, Catherine. About 2 weeks ago, on the dialogue forum, Gregory Stanton, John Packer, and Aaron Farrell Rosenberg, look at this issue from different angles, and something that Aaron brought up, which was the essentially almost a generation it took for one case to settle on reparation. I mean, 20 years, she said. Yeah. So when the survivors of the genocide, in this case of Rohingya, when they look at ICJ or ICC, I think I don't think they're thinking that the even limited judicial form of justice may take a generation for them. And that may even be quite a fast the kind of delivery, because if you look at what happened in Cambodia, 1979, when the genocide ended in January, the Khmer Rouge Tribunal, the extraordinary chambers of the Court of Cambodia, is just winding down after 40 years after the fact. And so I think that for those who are listening, particularly Rohingyas and Burmese activists, that we need to be very realistic and not pin our hope on international judicial processes. And as Catherine said, the real work remains to be done in the country and in the neighboring countries of Burma. Now I want to return to Mike's point about the upcoming public hearings. We are no longer looking at the status quo of the landscape within the court. Gambia Minister for Justice has been replaced with someone else, but that's far less consequential than the Myanmar side, right? We're looking at Myanmar as not as a government per se at the moment. We're looking at Myanmar as a state party. So now the question is hotly contested: who should represent the state of Myanmar? The state party in the Genocide Convention, being accused of having breached the treaty obligations of the Genocide Convention. Should Myanmar regime that has not succeeded in attempting to dislodge the existing previous government appointed representative of Myanmar at the New York headquarters, the Jomoton. And so we have a scenario where the United Nations, for whatever logics and reasons, decided to keep the status quo of retaining the old ambassador appointed by the ousted government over the objection of the coup regime. Right? And Mike, you have also mentioned, in our private conversations, that this postponement of the decision to decide whether Myanmar regime should represent or seat its representative at the UN body and other places does not amount to the regime being completely rejected, right? So, it was a postponement of the decision, or the need to make the decision. So in this scenario, ICJ being the principal judicial body of the United Nations, What happens in New York, will that cross the minds of the 15 judges plus 2 ad hoc judges? And if so, what are the likely legal reasonings for accepting Myanmar's team if ICJ obviously has been in communication with the Burmese regime? And then I've got a follow-up, a short one after that.
Okay. Yeah, I want to speak to that, and thanks for giving me the chance to do that. Can I say, I want to make just one quick follow-up point to what happened before, what Catherine's great intervention, and I'm so glad she read out the piece from the 2 youth leaders. I just want to point out, because Zarni, you referenced the fact that there's this other case that was just decided. We had just had a judgment this week between the DRC and Uganda, and this is the case that Aaron Rosenberg was referring to in the other roundtable, where it did take 20 plus years, so a generation, to go from when the case was filed to when the judgment on reparations came out. And that's true, but I want to mention this now just for people listening to understand that that is a complete outlier. Yes, ICJ cases take a long time, but the facts of that case are extraordinary because the case was decided in terms of the fact that Uganda violated international law back in 2005. And the court, in retrospect, maybe made a mistake, allowed the parties to go off and negotiate what that compensation was going to be. And the court, perhaps should have put a 1-year timeline on those negotiations or something like that. Instead, it dragged out between the parties for 10 plus years before those negotiations failed, and they went back to the court and then further dragged out the court proceedings. So it's not really I don't want people listening to this to think that ICJ proceedings or other court proceedings mean that you're going to be waiting, that it's typical to wait for 10 or 15 or 20 years to get a result. I just wanted to make that point. That's not normal. And if this Myanmar case makes it to the merits and the Gambia prevails, yes, it takes time, but it's not going to take time like that. But that doesn't take away from the point Katherine is making, which is that these long drawn out processes can perhaps lose sight of the need to deal with people's deprivations in a much more immediate and material way. Okay, now your question about who should represent Myanmar at the ICJ in these proceedings, what's going to happen now? I think you're right, Zarni, that it seems clear that the ICJ has been in contact or communicating with the military regime. And the wrinkle here is that just in the last couple of weeks, now the National Unity Government has stepped forward, and the permanent representative from the old pre-coup government, who still, as you explained, Zarni, still has the seat at the General Assembly, they've written to the court to object to the case proceeding with the military regime representing Myanmar and the new agent that the military regime has presumably appointed to represent Myanmar, replacing Aung San Suu Kyi, who's detained. The fact that the NUG and the permanent representative, more so the fact that the permanent representative to the UN in New York have objected, this now puts the court in a really hard place, an even harder place than they were before, I think, because it's harder for them to simply proceed kind of business as usual. I think they need to deal with this in some way now. The National Unity Government and the permanent representative in New York and lots of civil society actors and NGOs are making the argument that it should be the National Unity Government who is allowed to represent Myanmar in these proceedings. I think that that's a hard argument to accept. I don't think the ICJ will go that way. What I do think now is that there's a possibility that because of these competing claims, the ICJ might decide that the only thing it can do is suspend the proceedings, postpone the hearing until this question about who lawfully represents Myanmar is decided somewhere else, whether that means in the Credentials Committee at the UN General Assembly or elsewhere. I don't know that they will do that, but but now it's more of a possibility, I suppose, than it maybe was 3 weeks ago. Whether that's a good outcome, I think is really debatable. Now, I know some people will say, yes, that's absolutely the right outcome, because to afford any kind of legitimacy to the military regime by allowing them to represent Myanmar is extremely damaging. It will be damaging to the pro-democracy movement in Myanmar. It perhaps puts Rohingya, whether in Myanmar or in Bangladesh or elsewhere, at risk, because they might be accused in some way of helping to facilitate the legitimacy of the regime, because they're the case is about the Rohingya. I get that. I understand those arguments. On the other side of the ledger, the idea of the case simply being delayed indefinitely also seems like a pretty bad outcome. It is an outcome that the military regime is probably perfectly happy with, because then they don't have to deal with this and they don't have to defend themselves. It puts even further off however we want to marginalize the potential justice that the ICJ process can be a part of, understanding that it's a slow process to begin with. This puts that even further away if the case is simply suspended because of this disagreement.
Yeah, can I just further interject? What if the military regime that has been practically deprived of any type of acceptance and legitimacy, even within the Association of Southeast Asian Nations, with very, very low bar on constitutional rule or human rights or political civil rights? Just this morning, the Channel News Asia, essentially the official the broadcaster for Singapore, used the term Myanmar military's foreign affairs ministry. Yeah, like there was a piece about the Myanmar military regime writing to Interpol, asking the Interpol to arrest what it labels as terrorists, like NUG, the dissidents abroad, and whatnot. And this was not the journalistic era. It was a very carefully crafted term, Myanmar military's foreign affairs ministry, as opposed to Myanmar's foreign affairs ministry. You see what I mean?
Yeah.
So even if like a semi-democratic or benign authoritarian Singapore is unprepared to accord Myanmar military regime the status as a state actor, right? And if and when the court decides to allow Myanmar to come and have this public hearings and present its objections, don't you think it can also present a court with the risks in terms of global civil society's public perception at a time when people are losing faith and confidence in global governing institutions, from Security Council to other UN bodies?
Yeah, I mean, I think that's a risk. I think that would be a really unfortunate reaction to take away from this happening, if that's what happens. So what I think this really emphasizes that if the court allows the case to proceed and allows the military government to put forward the legal team representing Myanmar, it's important for the court to address that and to make the point, not only in an eventual judgment on the preliminary objections, which won't come until the summertime probably, but in the course of the hearings, I think the court needs to make very clear that it's aware of the fact that there is a situation of contested governments going on, and should emphasize that, I think it would be a good idea for the court to emphasize that allowing the military government to represent Myanmar in the ICJ case is a decision that has no legal consequences beyond the confines of that case. Now, that may sound strange to non-lawyers who might think, how can that be? How can you create such a kind of artificial distinction? But as a legal matter, it's true. There is no automatic legal consequence anywhere else because the military regime represents Myanmar in the case. So for example, it does not then compel the General Assembly to allow the military regime to replace the current ambassador to the UN with its own person. It doesn't compel any other international organization to suddenly afford recognition to the military government. And it certainly doesn't require any individual states to suddenly recognize and deal with the military government in their bilateral relations. So I think it would be a good idea. I think it would be prudent for the court in general, but also to deal specifically with this question you're raising, Zarni, about how will civil society react or understand this. I think the court should be proactive here in saying, explaining why it's proceeding with the case. And there are different, I can think of some possible arguments and people may or may not find them persuasive. But regardless of the reason that the court thinks the case should go ahead, I think they should be very clear about the fact that there's no kind of automatic, broader legal consequence to this. Now, that doesn't mean that the military regime won't certainly try to leverage the fact that it's participating in the case to convince other states to say, like, well, look, we are the actual government, and you need to deal with us and so forth. Of course, they'll try to do that, but the power to control how that plays out is in the hands of states and international organizations and civil society actors. And so I think I've said this to you in our own conversations, and I've said it elsewhere, I'm concerned that making such a big deal out of the fact of that the ICJ might proceed with the military government representing Myanmar, that risks being kind of a self-fulfilling prophecy. You end up handing the military regime the legitimacy that you're trying to prevent them from having by suggesting that it's an absolute catastrophe if the junta is allowed to represent Myanmar here. I think it would be prudent if that seems like kind of an inevitability, if that seems like where this is likely going, it makes more sense to start emphasizing now that the broader consequences of that decision are very small. This is simply about the case going ahead. This is about allowing the Gambia to have the claim it has legitimately brought to the court to be heard. It's about allowing justice for the Rohingya to move forward. And it does nothing, it is no comment whatsoever on the legitimacy or lawfulness of the current regime in Myanmar.
Katherine, I see you gesturing to the comment.
Yes, I just, as also a matter of sort of legal optics, there are a couple of considerations here, sort of building on what Mike was just saying, is that there is a kind of advantage in the military continuing to represent itself in this case, as it is putting itself, as the case itself exposes the military directly to scrutiny of its actions. It's not if it were the NUG or some other representative, then that would be filtered through that political entity, the scrutiny of what occurred in this particular case. So there is a kind of there is a kind of, this is in a way, while the military, as you point out, Zardi, in some ways sees this and might embrace this as a way of strutting itself on the world stage, it is nonetheless, and this again relies on us stating this and articulating this. This is nonetheless the Myanmar government on trial in a figurative sense regarding its failure to maintain its responsibilities, its direct failure. So the other point in terms of optics is that, as I mentioned this in passing, the NUG can also make statements and sort of shadow this case and sort of use it as a way to distinguish itself as as an alternative, and as a much more desirable alternative to the military regime. I mean, it doesn't have to do much at this point, but there are issues that some people have pointed out with respect to how much more the NUG could clarify and affirm its interest and commitment to assuring equal rights of the Rohingya, and by extension, all minorities in Myanmar, as a fundamental principle that would underlie the kind of government they would put in place. So this is there are opportunities here, and as Mike said, if it for some reason goes ahead with the military, we all who speak on this should be crystal clear. I think Aaron Rosenberg also mentioned this, that this does not have any legal consequence beyond the boundaries of this case.
Yeah, I mean, to play devil's advocate here, you know, NUG continues to be dominated by Aung San Suu Kyi loyalists and supporters, and you know, and then she continues to be essentially the iconic, you know, figurehead of the NUG. So the one question, I mean, that's very problematic, because there are a number of cabinet ministers who are on, you know, NUG's leadership committee or in the leading positions. They were directly complicit or involved in, you know, in basically genocidal process. You know, no less than the land confiscation of, you know, thousands of hectares of land that the Rohingya vacated when they ran for survival, you know, back in 2017. Yeah, and they're still cabinet ministers. So it's very difficult morally to see NUG as you know, as a clean party, as it were, because it had not come to terms with its own, you know, complicity of the top leaders, right? So that, okay, maybe that's, you know, that's a side point, but for me, you know, my question is, who has the standing, you know, insofar as the ousted regime with the court? Is it John Moton, the permanent representative that you know, Mike mentioned, or is it NUG? Because there seems to be a very clear surgical need to disaggregate NUG from the permanent representative, because, you know, like Mike, you said, and also NUG issued a press statement saying John Moton, ambassador from the previous government, would like to serve as the agent, right, in place of Aung San Suu Kyi, right? And so there are quite a few missing pieces here. There are holes here, you know. The NUG wants to claim political credit and saying John Moton is acting under NUG's guidance, right? That's the word they use, under NUG's guidance. John Moton is acting, but does John Moton need NUG insofar as the court is concerned? Because you pointed out, John Moton is is retained at the UN General Assembly as the representative of a democratically elected government of NLD, and NUG has not received, you know, however desirable alternative it is, has not received any type of you know, state recognition, even from the most supportive government in the world, that is the United States. So there are some serious intellectual and moral issues here. How do you respond to these objections or issues coming up?
Is that to me or to Catherine, or both of us?
To either one. I mean, both of you. Yeah.
Yeah. I mean, you're absolutely right, Zarni. It's I think of the permanent. I think it's easier to, and makes more sense, or is more coherent, to think of the permanent representative sitting in the UN as the representative of the deposed government, not as the representative of the NUG. He may be in discussions with the NUG, He may be trying to affiliate himself with the NUG and vice versa. But I think since the NUG hasn't been formally recognized either by anyone, that's kind of a non-starter. But I mean, he does have an argument that as the holdover from the deposed government, that he's in maybe a position to stop things. And this takes a page out of a case from about a little over 10 years ago, where there was a coup in Honduras. Right after the coup, the military regime in Honduras tried to bring a case against Brazil, but the old UN representatives from the deposed government on Honduras were still in place in New York, and they objected. They wrote to the court to say that this regime in Honduras has no legal authority to bring this case against Brazil. And so that was enough. And that, I mean, the posture is different. That was about bringing a case, not about representing a country in the middle of a case that's already underway. But the result from that Honduras case was that the court just froze everything and bided its time. And eventually Honduras withdrew the case, and that was the end of it. So the court kind of benefited by freezing things there. And so I've often come back to that example to think, well, this is a card available for the permanent representative of Myanmar in New York to play, and he's now played it. And will the court, do what it did in the Honduras case, suspend the case indefinitely, or proceed? And I don't know. I don't know what will happen. But I think it is really problematic to kind of frame this situation as the military government on the one hand and the NUG on the other, because it's just not quite right. It's this deposed government which doesn't exist, sort of, maybe except in the person of the permanent representative at the UN, and then the NUG and the military, and that creates complications just as you described, Zarni. Maybe Catherine has more coherent thoughts on this than I do.
Yeah, on the ground, the arguments coming from different quarters, even within ASEAN region, is that Myanmar no longer has an effective and clear state actor as such, because the regions are under different administrative and literal control of different armed ethnic organizations. Taxation systems are double in other places, so we are looking at a country where there is no actor that is emerging as the winner that can claim effective control over the population, the territories, or recognition of different states, and being able to enter into international or interstate affairs as uncontested party, right? So Catherine, I think you I understand like you have to go soon, and so if you want to share your final thoughts on take time, but on the issues that are in question now.
This issue of the representation is really thorny, and we can I guess one question to bring into this again is to consider. A consideration is again, what would, not that it's legally required, but sort of ethically required, what would the Rohingya want? How would what outcome here would serve them and the rights that we want to sort of actualize for them through this process to the extent possible? So I'm not going to say what they would say, but I do think there is, I will say that my own sense is that there's value in this case proceeding, because I have faith in the ICJ as an institution to continue to look at the issues dispassionately, and to and in some ways, if the representative is the military at this point, then in some ways, whatever outcome we have will perhaps have more of an appearance of authority than if it were some real contestable, as contestable or more contestable representative. Because, so I'll just leave it there. So again, as a final thought, again, is I hope that when we're thinking about these things, that we try to center again the interests and understandings that the Rohingya and other affected groups bring to the discussion of what justice means.
Mike, I'll give you the last word.
Oh, well, I kind of thought that should have been the last word, because Katherine said it so well. What can I do? I agree with, I really agree with what Katherine has said here. It's important to think about if we have the option of deciding which of these situations in terms of going forward at the ICJ, if you're advocating for one or the other, how does that play into the views of the Rohingya community? Although I guess I would add to that, and Katherine already hinted at this, the views of the Rohingya community are not necessarily a monolith either. There may be people in the Rohingya community who desperately want the case to go forward, even if they know it's full of uncertainty in terms of where it will lead. And there may be other parts of the Rohingya community who say, this was always, I don't trust the ICJ process to lead anywhere, and it's more important right now to pursue the goals of solidarity and coming together with other ethnic groups, maybe from which we were previously excluded, who now see us in a new light because we are united in our opposition to the military regime. So it seems to me there are very possibly conflicting or just different views within the Rohingya community too. I do think that it's unhelpful in these discussions about the representation issue to kind of vilify the ICJ. They've been put in this position because ultimately there's been a failure by states or other actors to deal with the representation issue. And the ICJ is doing the best that it can, I would say, to fulfill its particular judicial function within this complicated and highly political international system of which it is a part. So I guess I would maybe say we should keep that in mind, however this plays out over the next few weeks as well.
Thank you so much to both of you. You've been listening to Michael Becker at the Trinity College Dublin, and Katherine Southwick, Dr. Katherine Southwick, with the U.S. Holocaust Memorial Museum. Thanks so much, and I'm sure we'll come back, around the public hearings, and we'll be watching very closely whether the court will proceed with the public hearings, 4 days, I believe, until the 25th of this month. Thanks again, and have a good rest of the day.
Thank you, Zarni. Thank you, Katherine.